Okay, let's unpack this. Have you ever felt like you need a legal Rosetta Stone just to figure out what you're signing when buying land? You get handed this like huge stack of documents and you just kind of nod along hoping it's all okay. It's a massive commitment, right? Often one of the biggest buys of your life. Welcome to the deep dive. Today, we're taking a closer look at a really foundational piece of legislation from South Africa, the Alienation of Land Act 68 of 1981. Now, I know it might sound a bit dry, but honestly, it's packed with crucial protections and, well, pretty fascinating details that affect anyone involved in property deals. Buying, selling, just curious. Our mission today, to sort of pull back the curtain on this act. We've got the act itself, the definitions, the chapters, all the source material, and we're going to pull out the most important bits for you. We want to explain this act in a clear, engaging way, its purpose, the key rules, what it actually means in the real world. So whether you're just curious about property law or maybe a law student looking for that aha moment, hopefully this helps.
Yeah, and what's really interesting here is that while the Act originally dates back to 1981, it hasn't just sat there gathering dust. It's been consistently updated. The last big changes were in 1998, and it was even reviewed as recently as March 2025. So it really shows its ongoing relevance, how it keeps up with the changing landscape of land deals.
Right. So at its heart, what's the core problem this law is trying to solve? What's it regulating?
Well, its main job is to regulate the alienation of land, basically, selling or transferring ownership. But, and this is key, only in very specific circumstances. Critically, it focuses on sales where payment is made in more than 2 installments. That's over a period longer than 1 year.
Yeah, okay, so not just any sale.
Exactly. It's not about every single land sale. It's specifically designed to protect purchasers in those longer-term installment-based deals where buyers might be, a bit more vulnerable. Think of it like a safety net.
Got it. Okay, let's jump into Chapter On then. This covers the basics, the formalities. It starts with Section 2, which seems pretty straightforward on the surface. Any alienation of land has to be an assigned deed of alienation. Sign of paperwork, basically.
It sounds simple, yeah. But here's where it gets really interesting for purchasers, especially after those 1998 changes we mentioned. Section 29A. This introduces a vital cooling off period. It gives a purchaser this powerful right to just revoke an offer or cancel that signed deed within 5 days after signing it.
Wow, 5 days, like an undo button? That seems like quite a bit of power for the buyer.
It is. And it's a genuine 5 days. The calculation is quite specific.
How does that work?
It excludes the day you actually sign the offer or the deed. And it also excludes any Saturday, Sunday, or public holiday. So you get 5 proper business days. It gives you real breathing room to think, get advice, maybe reconsider.
Okay, that's pretty generous, but I'm guessing it doesn't apply to every single situation.
You guessed right. Section 29A5 lays out some significant exceptions. This right isn't universal. For example, it doesn't apply if the purchase price is over or $250,000, though the minister can change that amount. Or if the purchaser isn't an individual, but say a trust or a company, what they call a juristic person.
Okay.
Also doesn't apply if you bought the land at a proper public auction, advertised beforehand. Or if it's basically the same deal for the same land you'd agreed to before. Or if you have the right to nominate someone else to take transfer. Or if you exercise an option to buy that was open for at least 5 days anyway.
Right, so those are important limits to know. You need to check if your specific situation fits.
Definitely. Understanding those exceptions is key to knowing if you have that cooling off right or not.
And the Act is pretty firm on this, isn't it? I saw something about penalties.
Oh, absolutely. Section 29A7 makes it crystal clear.
Yeah.
Any clause, any agreement that tries to make you pay a penalty or fee for using that cooling off right, it's totally void. Doesn't count.
So you really can't sign away that right, even accidentally.
Exactly. The protection is built in. Now, just quickly on auctions, Section 3 mentions them. While the rule about needing that formal signed deed in Section 2 doesn't strictly apply to public auctions, if that auction sale does involve those long-term installment payments more than 2 over a year, then the special protections in Chapter 2 do kick in.
Ah, okay. So even auctions aren't totally exempt if they involve installments?
Right. In that specific case, the conditions of sale have to be read out loud right before the auction starts, and the seller must give the buyer a copy of the contract immediately afterwards. If they don't, the buyer might even get the right to cancel. It's all about transparency.
Makes sense. Okay, so let's move into Chapter 2 then. You said this is the heart of the Act for protecting installment buyers.
Yes. Chapter 2 is really the core of it for the type of contract defined in the Act. This is the shield for the purchaser buying land on installments. It's worth noting, though, Section 4 says this chapter generally doesn't apply if the seller is the state or certain other public bodies. But for most private sales,
Right. For most people listening, this chapter is likely the most relevant if they're considering an installment plan. So, what are the big protections here? What jumps out?
well, first off, something simple but important from Section 5. The purchaser gets to choose the official language for the contract. That ensures you understand what you're signing.
Okay, basic but necessary. What else?
Section 6 mandates a whole list of things that must be in the contract. This is all about transparency for you, the buyer. It covers the basics like names and addresses, of course. A full description of the land. Is it an ERF, like a stand, or a unit in a sectional title scheme? The exact purchase price, the interest rate, the installment amounts, when they're due.
Pretty detailed.
Very, and it goes deeper. For instance, if the seller isn't actually the registered owner yet, the contract must state the owner's name and address. Same thing if there's a mortgage bond on the property, the bank's details have to be there, or any other intermediaries involved.
So you know the whole chain of command, essentially, or the chain of debt.
Precisely. You know exactly who has an interest in the land. The contract also needs to specify who pays transfer duty, when you get possession, when occupation happens. And, crucially, it must state the latest date by which the land has to be registrable in your name. This means legally ready for transfer, and that date can't be more than 5 years from when you signed the contract.
5 years max. That seems like a reasonable time frame. What happens if the seller doesn't meet that deadline?
That's where Section 6.5 gives the purchaser real leverage. If the seller can't get the land registrable by that date, you, the purchaser, can choose. You can either cancel the whole contract, or you can choose to stick with it but stop paying any interest until it is registrable.
Okay, that's a significant penalty for the seller, a big incentive for them to get things sorted out.
Definitely. And the Act is really built to stop buyers from walking into financial minefields they don't know about. Sections 7 and 8 are about this. The seller has to give you certificates from anyone holding a mortgage over the land, Section 7, and from any prior sellers or intermediaries involved, Section 8, showing exactly how much debt is still outstanding on the property.
They have to provide this.
Yes. And if they don't provide these certificates, or if the amounts shown on them add up to more than the price you agreed to pay, you can cancel the contract, full stop.
Wow. That really highlights how complex these deals can be. You're not just dealing with your seller, are you? There could be layers of existing debt.
Exactly. And the Act anticipates this. Sections 9 and 10 even give you, the purchaser, the right to go directly to those mortgage holders or previous owners' intermediaries yourself and demand that information if the seller isn't forthcoming.
So you can bypass a difficult seller if needed.
You can. And then there's Section 11, which is quite a powerful protection. Let's say the owner of the land or some intermediary seller before your seller stops meeting their obligations. Maybe they stop paying their mortgage on the land you're buying.
Right, which could put my purchase at risk.
It could. But Section 11 says you, the purchaser, or even a remote purchaser down the line, can actually step in and make those payments directly to the bank or whoever is owed.
I can pay someone else's debt.
Yes, to protect your interest.
Mm.
And here's the kicker. Any payments you make like that, they count directly towards what you owe your seller under your own contract.
That's incredible. So you don't lose the land just because someone higher up the chain messed up.
Exactly. It prevents you from losing everything due to someone else's default. It's a really significant safeguard. Chapter 2 also has other financial protections. Section 12 lays down rules about how interest is calculated, stopping sellers from charging excessive amounts. It limits what sellers can claim back from you if things go wrong.
And there's that point about getting a copy of the contract too, right? Section 13.
Yes. Seems basic, but crucial. The seller must give you a copy of the signed contract within 30 days.
And if they don't?
If they fail to provide it after you've asked in writing, you're actually not liable for any interest on the purchase price for the period they're late in giving it to you. Puts the pressure back on them.
Good incentive for them to be organized. What about unfair clauses? Can they sneak things into the contract?
Well, Section 15 tries to prevent that. It specifically makes certain types of unfair clauses completely void, invalid. Things like a clause saying the seller's agent is also acting as your agent, or a clause where you forfeit any claim for necessary improvements you made to the land if the contract gets canceled, or forcing you to take out a loan from a specific person named by the seller.
So the Act just cancels those out automatically?
Yes. It ensures these basic consumer protections can't just be signed away in the fine print. It reflects a strong public policy.
So again, you can't accidentally waive these fundamental rights. That's really the theme here.
It really is.
Yeah.
And for ongoing clarity, Section 16 requires sellers to give you regular, detailed statements of account, at least once every 12 months, free of charge.
Showing payments made, interest charged, balance owing.
Exactly. And again, if they fail to provide it after you request it, you're not liable for interest during that delay. Keeps everything transparent.
And you're not totally locked into the payment plan either, are you? Section 17.
No, you're not. You have the right to pay installments early or pay bigger amounts. And if the land is legally registrable, you can demand transfer once you've paid everything owing, even if it's ahead of schedule. Gives you flexibility.
What about if the purchaser messes up? Say, misses a payment. Does the seller just get to cancel immediately?
No, the Act limits that too. Section 19 is important here. Before a seller can cancel the contract or sue you for damages because you breached the contract, like missing a payment, they must first give you written notice. And that notice has to give you at least 30 days to fix the breach, to catch up on the payment, for example. Only if you fail to fix it within that time can they then take action.
So there's a mandatory warning period, a chance to sort things out.
Correct. It prevents immediate, harsh action. And then there's Section 20. This is a cornerstone, really, the recording of the contract. The seller is obligated, they must apply to have the contract recorded against the title deed of the land in the deeds registry.
They have to record it. Why is that so important? What does it actually do?
It's crucial. If the seller doesn't do this within 90 days of the contract date, then you, the purchaser, have a choice. You can either cancel the contract entirely, or you can apply to have it recorded yourself.
Okay, but why bother recording it? What's the real-world impact, especially if, say, the seller gets into financial trouble later?
This is the payoff. Recording the contract gives you what's called a preferent claim. Section 20, subsection 5 spells this out. It means if the land is later sold in execution, like the sheriff sells it because the owner owes money, or if the owner goes insolvent, bankrupt, your recorded contract gives you a high priority claim on the proceeds from that sale.
High priority, like ahead of other debts.
Your claim ranks immediately after any mortgage bond that was registered before your contract was recorded, but it comes before most other creditors. It's a massive protection. It significantly increases your chances of getting your money back or even securing the land itself if the seller hits financial rocks. It stops you being just another unsecured creditor likely to get nothing.
Wow. Okay, that recording sounds absolutely vital then, not just admin.
Not at all. It's a core protection. And speaking of insolvency, Sections 21 and 22 deal directly with that scenario. Section 21 sets out a clear process. If the registered owner becomes insolvent or the land is attached by creditors, the trustee or executor or the sheriff must notify any purchaser whose contract is recorded.
So you get formally told what's happening.
Yes. And then Section 22 gives you, the notified purchaser, a powerful right. You can choose to take transfer of the land, provided you make arrangements to pay the transfer costs, and any amount still owing under any prior mortgage bonds, plus your remaining balance.
So even if the seller goes bankrupt, I might still be able to get the land.
Exactly. You have the right to essentially complete the purchase, securing your investment despite the seller's financial failure. It's designed to prevent you losing both your payments and the property.
That's a remarkable level of security for the buyer in a tough situation. Okay, just to recap Chapter 2 then, because there's a lot there. If I'm buying on installments, what are maybe the top 3 protections I should absolutely remember?
Good question. Top 3. First, I'd say the mandatory contract contents and that transparency about all parties and debts, knowing exactly what you're getting into. Section 6, 7, 8. No hidden surprises. Second, probably that right to step in and make payments if the owner or intermediary defaults on their debts. Section 11. That ability to protect your own interest is huge. And third, definitely the recording of the contract, Section 20, and the preferent claim it gives you. That security against the seller's insolvency or the land being sold off is just critical. Those 3 really stand out.
Got it. Contract transparency, right to step in, and the power of recording. Okay. What about Chapter 3? You said general provisions.
Yeah, Chapter 3 has some general rules that reinforce everything else. Section 26 is a big one for preventing certain types of fraud. It says that generally, no one can receive any payment, any consideration for selling an IRF or a unit until that property is legally registrable A&D, if it's an installment contract under Chapter 2, until that contract has been recorded.
Hold on. So sellers can't just take your deposit or initial payments right away if the land isn't even ready to be transferred or the contract isn't recorded yet.
That's the general rule in Section 26. It's designed to stop sellers taking your money for something they can't legally deliver yet. But there are important exceptions.
Okay, what are they?
Money can be paid, provided it's held in trust by a legal practitioner or an estate agent. Or if the seller provides an irrevocable and unconditional guarantee from a bank, building society, or registered insurer to basically pay that money back to you if the land doesn't become registrable or the contract isn't recorded as required.
Ah, so there are safety nets. The money is held securely by a third party or guaranteed.
Exactly. It ensures your funds are protected until the legal requirements are met. Then there's Section 27, another powerful right for purchasers in installment contracts. If you've paid at least 50% of the purchase price and the land is registrable.
Halfway there.
Right. At that point, you can actually demand transfer of the land into your name immediately.
Even if I haven't paid the full amount yet.
Correct. The process involves registering a first mortgage bond over the property in favor of the seller for the outstanding balance you still owe them.
So I get ownership earlier, and the seller gets security for the rest of the money.
Precisely. It allows you to secure your title to the property much sooner, which can be very advantageous. And Section 28 deals with what happens if a deed of alienation is void-like, invalid from the start, or if it gets terminated for some valid reason. It provides for equitable relief, basically fairness.
Meaning?
Meaning, generally, you, the purchaser, can recover everything you've paid, plus interest at a prescribed rate.
Yeah.
You can also claim compensation for any necessary improvements you made that actually increase the land's market value.
And the seller.
The seller can claim reasonable compensation from you for your occupation or use of the land and for any intentional or negligent damage you caused. It tries to unwind the situation fairly for both sides.
Right. Attempts to put everyone back where they started, more or less. And finally, Section 29. We touched on this with the cooling off period, but it seems broader.
It is. Section 29 is a blanket statement. It says that any waiver by any party of any right conferred by this act is null and void. Finished. Invalid.
So you absolutely, positively cannot sign away the protections granted by this legislation.
That's the long and short of it. It underlines just how seriously the law takes these purchaser protections. They are fundamental and cannot be contracted out of.
Okay. So bringing this all together then, what does this mean for you, the listener? Whether you're maybe thinking about buying land on installments, or perhaps you're already in such a contract, or even if you're a law student trying to get your head around property law, this act is clearly a major piece of the puzzle.
Absolutely. The Alienation of Land Act, particularly Chapter 2, isn't just dry legal text. It's a really vital framework. It's designed to bring transparency, fairness, and a significant amount of security into what can be very complex and sometimes vulnerable transactions, especially those long-term installment sales. It makes sure purchasers aren't left totally exposed to things like hidden debts or sellers defaulting or completely unfair contract terms. It gives you clear rights and steps you can take. It really embodies the idea that knowing your rights is crucial.
Yeah, this whole deep dive really highlights how specific laws like this can profoundly shape the safety and fairness of really fundamental transactions like buying land. But it also makes you think, doesn't it? As property markets keep evolving, maybe we see more digital transactions, new ownership models like fractional ownership popping up. It raises a question for you to consider. How do we make sure our legal frameworks, like this act, continue to keep pace? How do we ensure they keep protecting individuals and building trust in these vital parts of our economy and lives? Well, thank you for joining us on this deep dive. We really hope this has shed some light and maybe giving you some surprising facts about a really crucial piece of South African legislation.
Yeah, always more to unpack, isn't there? Different perspectives always help. Keep digging and keep asking those critical questions.